Uh-oh.
I'm ready. Are you?
I am.
Something strange.
Very faint, but I think we're good.
Okay. Good evening. It's 5:30 p.m. on Tuesday, February 7th, 2023, and this regular meeting of the Sandpoint Planning and Zoning Commission is now called to order in council chambers at City Hall, 1123 West Lake Street, Sandpoint, Idaho. For the record, I am Chairman John Hastings presiding. Also present are Commissioners Grant Simmons, Mo Stunkel, Slate Camp, Amelia Boyd, and Ben McGran. We will now recite the Pledge of Allegiance. If everyone will please stand. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. As a reminder, there are listening devices available to anybody in attendance, counseling chambers, and available up front with the clerk. Are there any other general announcements from commissioners or city staff? Seeing none, the next item on the agenda this evening is a commissioner training, and I will now yield the floor to City Planner Amy Tweeten for an introduction.
Thank you, Chairman Hastings. This is a training we try to do annually. Again, you're faced with a lot of different approval processes, and when you're new to the commission, you get this training, you get the background, and then you have a year and you have cases. And so we want to come back and kind of go over the subjects again, because it might prompt some question that from a previous case you had, or the way something was handled maybe wasn't the way we're going to kind of lay out the ideal way that meetings should be run. So I was going to start. I can find my PowerPoint. No, that's not it. Sorry. Where is? So I was just going to start with the broader overview and then turn it over to Fonda for the more legal aspects that you are often faced with. So again, Fonda Jovic is here as our legal counsel. She or Zach will generally be here. And then I'm your regular staff person. So planning and zoning at the municipal level is dictated by the state is the enabling body that says this is how you can regulate land use, and that is through the Local Land Use Planning Act of 1975. And the general purpose, again, of planning and zoning is to protect the health, safety, and general welfare of a community. And the state statute goes through all these different components of how that is accomplished through planning and zoning actions. So the role of the Planning Commission in the planning and zoning realm is you are an advisory board to City Council on many of the actions before you. You're all volunteers. Again, you're looking both at planning matters short-term and long-term. And then some cases you actually are the final body, such as a conditional use permit is an action that comes before you that is not a recommendation to City Council. And again, your role is an intermediary between the elected officials and the public. And again, the idea of a planning commission came up to try to remove politics from land use decisions. And it also, by you holding a public hearing and then making a recommendation to City Council, there's just that much more opportunity for the public to have their say. And then you are doing a big part of the land use workload for City Council. And then you have several different roles. Again, when things come before you, you're reviewing them against policies in the comprehensive plan. You're advising the City Council by your recommendation on different actions. There are certain procedures that the state law and the city code lay out that you have to follow. Sometimes City Council will ask the Planning Commission to do some of the research on different items for them. Obviously, you work closely with staff. And then you are also put in the position of implementing policies that City Council has adopted. And then you always have that hat of the long range. How does this better it's not just the application before you, but how does it fit into the broader community and the broader good? And always looking to the future of whatever these decisions, the decision before you, how it impacts future consequence. So what's the role of staff? Whether that is Fonda or myself or Sarah, we are your liaison or your research arm, and we're always here to answer any questions you have, whether in a public meeting or if you want to reach out outside of a public meeting. We provide the background information, required public notices, make sure all the legal requirements of an application are met before it gets to you. And then the minutes and just technical aspects of planning and zoning. And then there's other staff as well that assist with the commission that may or may not attend, whether that is the city engineer, the infrastructure and development services director, the parks development and planning manager. So there's a lot of different staff. Sometimes their input comes through us into your staff report, and then sometimes they will be here at the meeting. Again, you are dealing with land use issues, which can be contentious. And Fonda obviously will talk more about the legal aspects, but again, they're just consider that you are as a member of the city and the city's overall liability is yours, but you are protected as a volunteer member of the commission. And it's always just best that it's exactly why we have Fonda at meetings, because often procedural questions do come up, and our legal counsel is the best or most knowledgeable on doing something and not getting ourselves in trouble. And then if something discriminatory comes up, don't let it just lie. Make sure that that gets addressed. In your world, a big part of it is the comprehensive plan, which we're in the process of updating. Again, that is a planning document, a visionary document looking out 20 years. The state code requires 7 different elements to be included in that. And the plan is creating that framework for the zoning ordinance and additional policies moving forward. So again, it's a planning document, and that creates codes such as the zoning code, which is Title 9, and the land division code, which is Title 10. The zoning, the plan is the vision and the zoning ordinance is law. So you'll notice in staff reports often will say, these are the goals and objectives of the comp plan. These are the standards in the code. And it's the standards in the code that must be met. And we hope that the standards in the code are reflecting the broader policies of the plan. That's the goal. Again, the codes regulate land use form and lay out what the procedures we follow. Land division is Title 10, and we have had a zoning code in place in Sandpoint since 1941, which is quite long for a municipality. So that I just wanted to give you a lead in to Fonda's presentation and just really thank you for your service.
Thank you. Thank you.
You're also quiet. So we're going to talk a little more about process. That's where I come in. There's some substantive information that I provide to you through the context of our meetings and applications and decisions that you need to make. But for the most part, I tell the majority of my commissions and councils at the end of the day, I don't care what your decision is, as long as it's defensible. So we're going to talk about the best way to make those decisions defensible and thorough in relationship to protecting the city. My name's Fonda Jovic. I know all of you. I think that we have a new commissioner. It's nice to meet you. I have been practicing law for 20 years. I'm an attorney, managing partner with Lake City Law, and I do a lot of municipal work. So the rest of my practice, I do estate planning and probate, which is completely different from this. And I like to have that little bit of difference. And then I mediate part of the time. But tonight we're going to talk about land use and process. So this should be, okay, why is it not? Hold on. Technology is great until it's not. There we go. So Amy started to talk a little bit about who all the players are here, and I have another slide in relationship to that. Most of you know Amanda Wilson. She's the director that leads this team. Christine Coleman is our building official and also our deputy fire marshal. So in land use related applications, when there's comments and or information pertaining to fire safety, you'll see some information that will come from Christine. We oftentimes forget that's also the other hat that she wears. We have Amy and I, who you see a lot, and Miss Sarah, who is our associate planner and the, what do I want to call you? Like the big brain in the room that has every code section memorized. If ever you have forgotten a code section or the numbers related to that, we just call Sarah because she will tell you word for word what it says. And then I'm a consultant, however, appointed. So Idaho code requires that your city attorney be an appointed position. And I and Andy Doman, my partner, are appointed. And then Betsy Roberts is still working as our interim city engineer. So again, we're going to talk about process. You have a couple different types of public hearings that you are responsible for. I think this one went one too far. Hold on. I'm going to go backwards. Just give me a second. Maybe.
Open. Let's see the green arrow.
Mm-hmm.
Now share.
And I did it from there before, but then it didn't want to. Let's see.
There you go.
Can I open it all the way up or should I just leave it there? Let's just not touch it.
That's fine. That works.
Yeah, it's hard when you don't have a mouse.
No.
It's fine to leave it like that if you want.
It's okay
Yeah.
with you guys? Okay.
Yep.
So your roles and responsibilities include overseeing and governing the process of legislative hearings and quasi judicial hearings. We're going to talk about the difference between those two things. And then the obligation within those hearing procedures to have solid deliberations and make findings. You've heard me say before, findings of fact. What does that look like? We're going to talk about that tonight. You're responsible for the outcomes and motions that come out of those applications in that hearing process. And what do I mean by that? All of your conversation, as you know, is recorded and then has to result in a written decision. And then you approve your written decision. All of that becomes the basis of what we call the record. And the record is really critical because every affected person or applicant has a right to challenge your decision or challenge city council's decision. And we need to be able to create, we're required by Idaho code to be able to create a transcribable record. So not just what is said in the hearings and that verbal transcription or the transcription of that verbal hearing, but everything that has led up to that from application through written decision. And so you become responsible for the outcome of those decisions and how our record looks, if you will, when that happens. And we have recently had a situation where we had to transcribe a record, and that particular application had come through planning and zoning. We had a pretty robust hearing at planning and zoning. You made a final decision. That decision was appealed to city council. We had another public hearing at city council. And then there was a request for reconsideration of that decision, and city council affirmed their decision. And then that was taken up to district court on a petition for judicial review. So at the point that that petition for judicial review is filed with district court, the city's obligated at that point to put together the entire record that we lodge with the court to include those transcribed hearing procedures. That record, that just the transcribable record in that particular action was $1,800 just to get the words on paper. So just kind of keep in mind as we are holding public hearings and I'm holding you to the process, part of that is to make sure we have a clean record. And many of you have heard me say that before. And then there are a number of different other land use items that you encounter, you'll encounter through this process. So whether it's looking at code text amendments, so you've seen code text amendments come through and be discussed here, whether it's comprehensive planning, you're right in the middle of all of that. So everything land use related in the city will touch you at some point, whether you're the final decision maker or not, it will touch you. Before we launch into the hearings, I'll give just a brief explanation of how our system evolved. And Idaho doesn't have as robust of a land use system as like Washington or some other states. And the reason for that is we're a Dillon's Rule state. So Dillon's Rule is an old Supreme Court case that says if the legislature doesn't specifically and expressly authorize the municipality to do something, you don't have the authority to just do it. So we've talked about this in the context of what can we do in relationship to affordable housing? What can we put in our code and what can't we put in our code? All of those decisions have to be rooted in what does our Idaho code say that you are allowed to do? And you have to operate within those confines. And that came about from the Idaho Constitution, originally gave cities police power to zone. So zoning was a police power. And the expectation was that under the zoning law, you would create the process and the expectations for the public. So the cities were authorized under the Constitution through the police powers to direct how their zones were going to lay out, what their zones were going to be, and then give the public in the form of your municipal code, the information on how the public can develop their property. Then in 1975, along came the Local Land Use Planning Act, and the Local Land Use Planning Act went one step further, and it said cities, cities and counties, you must plan and zone. It is your exclusive responsibility. We as a state legislature and Idaho code is not going to dictate how you zone, what your zoning code says. We're not going to say that all cities are created equal and you're all going to have the same zoning code. It is your exclusive responsibility to develop zoning code and code that lays out the expectations for your public of what they can do with their land and how they can do it, and what the process is going to be for them to get those approvals. So the Local Land Use Planning Act in 75 came forward and said, it's your responsibility. And you guys can ask me questions at any time too, just so you know. Go ahead. Yes.
I would like to ask a question. And I was just curious, the nexus between zoning and land use regulation, and how that fits into this whole process. If the state is requiring zoning, then where's
so land use rules fall into that category or that bucket of expectations for the public. So you're going to zone, and then you're going to build a zoning code that says in this zone, you can do X, Y, and Z. And that is land use regulation. But then so are design standards, and so are subdivision requirements and setbacks. Does that help?
It does. I've been reading lately, and how some cities and even states are starting to go entirely away from zoning and relying just upon land use regulation to accomplish the same objectives with less burdensome regulations, I guess. I don't know, but I'm just curious. Zoning is actually a requirement.
Our Local Land Use Planning Act would have to be completely abandoned for us to head in that direction.
I'm just curious.
Yeah, no, it's a great question.
Mm-hmm.
So in 1984, the city of Coeur d'Alene actually tried to leave zoning to the citizens. So they tried to have zoning applied or zoning rules designed based on initiative from the people, if you will. And the Idaho Supreme Court said, no, you cannot delegate zoning responsibilities to the public via initiatives and elections on zoning issues. So that further reinforced the authority of the municipalities to set those rules and not leave the decision-making, if you will, to the citizens with that Supreme Court decision. And the reason for that, if you want to read the case, I can give you the case site, but the reason is because the theory is that elected officials, i.e. your council members, are elected by the people to make informed decisions on behalf of the public. And so zoning is one of those areas of the law where the Supreme Court said we're leaving that decision-making with our governing bodies. And they've built in to the Local Land Use Planning Act many opportunities for applicants and or affected parties to get into court if they wish, if they don't like the decision of the governing board. So any questions on any of that? So then we talk from your perspective, and what you see day to day are different types of public hearings. So you have legislative hearings. So these are matters of general concern. These are code amendments, open-ended comments, meaning that you may have a discussion in your roundtable about something a citizen said to you, about general conversation, not specific to an applicant, not specific to a parcel. And then some of that comes to you in the form of a hearing. So we don't have to go through all of these in detail. You've seen a lot of this, but code text amendments will come to you. There will be a request that some code be changed, whether that request is coming down from council and you need to take the first look at it, or whether it's been city initiated because we have problems with the code, we have inconsistencies, whether there's been citizens that have requested we take a look at certain parts of the code. Those are legislative hearings. And the real important part of legislative is you can have conversation with the public about information. Your decision in that legislative hearing is not restricted to just the information you receive at the public hearing or in the record, if you will. That's your opportunity to really engage with the community and talk with them about matters of a general nature. I guess the last bullet point is kind of important. The closing of that public hearing, unlike a quasi-judicial, which we're going to talk about, the closing of a legislative hearing is not affecting a particular person's rights, specifically because of that decision. I'm not saying people aren't affected. It's just there's not a specific person that has been discussed, or a particular piece of land or a particular applicant whose rights are affected by that decision. So that's how you can remember legislative. Yes, sir.
Oh, I lost my train of thought.
I know how that happens.
Yeah. It'll come back to me at another time. Oh, that's what it was. No, it was when you talked about, part of our role is to get the pulse. I mean, we've already seen that, get the pulse of the community, and that it's completely acceptable. If we bring information to a meeting that came from the citizenry, we don't need to identify that source necessarily, do we? You
do not need to identify the source, but you should identify that you received that information in your deliberations when you start talking in the context of your deliberations about your decision.
Mr. Chair.
Yes.
Can I ask a question about the open-ended comments and maybe expanding on that a little bit?
Sure. Do you have a question about it, or you want me to?
I just wanted to know exactly what it means.
So that's put in there because one of the hearings you may end up with is you have a group of citizens who are concerned about a particular topic, and they want to come in and they want you to have a public hearing on that topic. Maybe there's not a particular decision point that you're going to have, but it's an opportunity for citizen engagement.
Okay.
So for instance, your community engagement workshops on the comprehensive plan are akin to open-ended comments where you may engage with the community. We may have a public hearing here on aspects of the comprehensive plan where that night there's not decision-making point. You're just receiving information from the community.
Okay.
As sort of the filter. I think you've probably heard me say you're kind of the kidney of the city.
Yes.
You kind of all land use related issues kind of filter through you. Any other questions on the legislative hearings? I assume we'll spend a little more time than this on quasi-judicial, and we're going to go to quasi-judicial hearings next. But I want to remind you, if you have questions, we need to not be talking about any specific project that hasn't already completed its final decision-making phase and all appeal periods have expired. So we could talk about a project from 2 years ago that is final, all appeal periods have expired if you have questions about the process. We cannot talk about anything that is between preliminary plat and final plat, because there's still an opportunity at final plat for somebody to appeal that decision. And so those are still considered active applications until that final plat is approved and the appeal period has expired for that. So if you want to ask questions in relationship to specific projects or applications, we just need to be really careful that we're not talking about anything that's currently active.
And what is the appeal period?
Well, so every final decision is, if anybody wants to appeal a final decision, they have 14 days to bring a request for reconsideration to the governing board. And then after the decision on the request for reconsideration, they have 28 days to file a petition for judicial review with district court. Gotcha. Any other questions on that? So quasi-judicial hearings, and they're called quasi-judicial, and this is an easy way to remember it. You are a judge. You only have a right to make a decision on the information that is presented to you in the context of the public hearing process. There's one exception to that. A land use related matter will allow you to drive by the particular property in question, and you can comment during deliberations about what you saw in that drive-by. Because of course, we can't bring the drive-by to the public hearing. So other than that exception, you can't make a decision based on your experience at a particular intersection and the traffic that maybe you suffered, the setback you suffered in traffic. You can't make a decision based on information from another application. You can't make a decision based on information that you went and sought out on your own that wasn't presented at the public hearing. So, and the reason for that is quasi-judicial public hearings are affecting some specific person's property rights. And your obligation is to weigh those individual property rights with the best interests of the city. And that's it's a hard job. Any of you who have sat here in these seats for a while or through any of our application process know that that is a really hard thing to do and you guys do a tremendous job. And the reason is because you all genuinely care and you want to get it right. I mean, I hear it. Your deliberations are generally very thoughtful and very solid, but you are weighing the public's interest with those private property rights. Due process is required. So due process means you have an applicant that's asking for something. You have a public that has a right to provide their commentary, but the applicant gets to respond to that. So everybody has a right to be heard. That's what due process is. And we offer the right to be heard to the public in a variety of different ways. They can provide written comment. They can come and they can speak at the public hearing. Oftentimes they'll have two shots at that, right? They'll have planning and zoning, and then they'll have an opportunity at council. So we offer many opportunities for people to be heard to protect the due process rights of everyone. So that notice and opportunity to be heard. You hear us say, you hear Amy say, and you see in your staff reports, the verification that all of the notice provisions have been provided for, that we've met Idaho code in relationship to those notice provisions. Here's my favorite, transcribable verbatim record. Really critical. Every public hearing, specifically those quasi-judicial, we have to be able to transcribe that record if anybody appeals that decision. And so it's important not to talk over top of each other. It's important that maybe we get back to the decorum that's required, where you ask your chairperson if you may speak. It's important if sometimes you'll have an applicant up here that you want to ask questions of, that you ask them, you finish your question, and then they answer. That's the whole point of not talking over top. The reason you asked your chairperson for permission to speak is so that when we transcribe that record, we don't just have many different people talking and nobody knows who it is, especially like this last time, if we have to send that record out to be transcribed by a professional court reporter. They don't know who any of you are. So now they have to try to watch the video and line it up with the audio to make sure that they have the name of whoever is speaking. So, and the longer it takes them to transcribe that record, the more money it costs. So those transcribable verbatim records are required by Idaho code, and it's a lot easier said than done when you actually have to have one. All of your primary topics for quasi-judicial hearings will be land use related. So you've seen those. You've seen variance, subdivision, conditional use permit. What am I missing? Rezone. Good one. Yeah, our favorite one right now. So they're all land use related. And then the last one, and I've said this a few times and I'll continue to say it, all of your comments that you use for your decision-making process and deliberations have to come through the public hearing process. And you should have no ex parte communication with anyone regarding the application outside of that public process. And towards the end of this presentation, we'll talk a little more about what is ex parte communication and what happens if you've had ex parte communication with someone. Any questions on this? This is like the bulk of the work that you do. Yes, sir.
Would it be beneficial if when people want to speak, I identified them
It would
by
be
name?
absolutely. Even if you just say Commissioner Boyd, yes, please
Exactly.
ask your question.
Because that would make that process much simpler should it come to that.
That'd be great.
Chairman Hastings.
Yes.
Good practice.
Just getting going. In the first point, specific rights of the individuals, I know I've said this in my comments about a lot of hearings that have come up. We've approved very similar projects like right next door to this one.
Mhm.
And I think what I heard you say is that's probably not a good idea to point that out.
You can point it out as long as it's not a basis for your decision. So if you're pointing it out, you're probably relying on that as part of a basis for your decision. So the answer to that would be no. And for example, Idaho code specifically states that a conditional use permit, so the approval of a conditional use permit cannot be used as precedent for the approval of another conditional use permit. So on that, in that particular instance, code even takes care of that for us.
So is that because each property, each individual is like, they have their own new beginning, new set of evidence to back up their application? They're literally right next door, like we've seen. We'll say it's not a conditional use permit, say it's a subdivision, and it is almost like a carbon copy of a previous one. Would there be any kind of issue if we didn't pass it and it was just because?
So a subdivision is a great example because that's a nice segue for me to remind you that a subdivision is a matter of right application. So you are required by Idaho code to provide in your municipal code the rules by which a person can divide their land. That's your job. And when they come to you and they have presented you with a preliminary plat or a subdivision application that meets all of the elements of your code, you don't have any room to deny it. It is a matter of right application because you said in your city code, here are the rules that you need to follow to subdivide your land. And then in theory, they've worked with staff long enough to make sure that the application they bring forward meets all of the elements of city code. Second to that, and we'll get to this statute a little later in the presentation, the Idaho code in the Local Land Use Planning Act, it requires that when you make a decision that you articulate the findings, and those findings have to apply to the standards of approval that have been put before you. And if you're going to deny it, you have to tell the applicant what they need to do to get approved. So subdivision and preliminary plat is it was a great kind of tipping off point for that question. And that's a piece that a lot of the public doesn't understand. So to the extent you are also sort of the ambassadors to the public of how land use related actions work, when people come into public hearings, and if they call me or they talk to Amy and they want to make public comment, we always encourage them, make sure your public comments are anchored in the standards of approval. Because just coming in and saying, I don't want my neighborhood to change, though we love the fact that they come out and they speak and they're here, that's not a comment that's anchored generally in the standards of approval. It's not helpful for you because you need something you can give weight to, right? And only you can decide how much weight you're giving. We can't tell you that, but the comments need to be anchored in what the standards that you're going to be evaluating. So did I answer your question?
Mostly.
Great.
I mean,
I say a lot of words. Most of the time it'll answer a question.
I know how that is. So on the topic of subdivisions, if an applicant comes forward and they ask for everything by the book, all their application is by code, all their sizes, setbacks, everything is exactly the way code is written. We just have to approve it, of course. Well, we have to approve it unless we see something wrong that isn't actually.
Which
Following
then would be
code.
identified in the staff report that they're not meeting code for whatever reason.
Okay, and then if they ask for a variance to the code or let's
A
say
waiver, let's not use variance.
okay, a waiver or maybe a longer distance from some kind of setback or something like that, then that's our leverage to possibly, if we don't want to approve that, then we're saying no to that, not just to the entire.
So that might be an example where you would say, I'm going to recommend denial to city council. These guys do recommendation. I get my cities mixed up. They're just a recommendation to council. Yeah. So you're going to recommend denial to council unless the applicant goes up to council by curing that deficiency. And they can do that between planning and zoning and council. You guys have seen that, where you've provided some comments or you've recommended approval based on certain conditions, like they have to meet A, B, C, and D.
So during the hearing, those topics can be added or subtracted from their application, and that is part of the hearing, and that becomes their new application if they choose to bring it forward to city council.
It's it doesn't change their application. It becomes your recommendation to council with conditions. Whatever your recommendation is. What we've talked about before, though, is we don't negotiate with an applicant from the dais, right? We're not doing that in the middle of a public hearing. So if it's significant enough, you have the ability to table your deliberations and ask for up to 60 days. It has to come back within 60 days or 40 days, 60 days. It has to come back within 60 days. So you could table your deliberations to ask staff questions, to get clarification, to ask that a condition of well, you wouldn't bring forward another condition of approval. You would just deny. You'd make a recommendation to council with your own conditions of approval. What we don't like to do is negotiate those with the applicant at the public hearing. So on one hand, I'm saying yes to you. Yes, you have the ability to add conditions or deny make a recommendation for denial unless the applicant does X, Y, and Z, as long as it's really clean. And if you have concerns like that before the hearing, you should be contacting Amy. So if you are thinking that something's missing before you read the staff report and you look through your packet and you're thinking, gosh, I really wish this was in there, call Amy first, because she's going to be able to tell you whether or not it was considered, it could be as simple as we told the applicant to do it and they're refusing to put it in there. Well, that's kind of your green light to say, I'm going to make it a condition, right? Things like that. You won't know what happened before the staff report came to you, and if you don't call Amy, if there's things in there that concern you. Or Sarah.
Well, in the past, I felt like we could have done a better job of that because there was opportunities for us to add or to not recommend approval because there was some issues. And since we didn't do our homework ahead of time, we kind of had to be coached along to. Which
is really hard to do in a public hearing.
Yeah.
It puts us in a really difficult spot.
Yeah, because I felt like the majority of the commission was in favor of not passing or not recommending approval. And we didn't really know how to get around it. But there was a lot of rookies here in those days.
Doing your homework, you're going to see that on a slide that's coming up also with regards to your responsibilities. And land use applications are complicated. There's nothing simple about land use. We throw volunteers into this spot and then we say, oh yeah, by the way, you need to understand the Local Land Use Planning Act, all of Title 9, 10, 11, and 12 of your city code. And oh yeah, and you're a judge now. So you should understand how that works too. And that's really a big ask. And so for your first year, probably year and a half, you're just, I'm sure Commissioner Boyd will, you're just scrambling. You're like, what am I doing? What am I reading? What am I supposed to be focused on? What am I not supposed to be focused on? That's what we're here for. Ask us anytime. So, yes.
I think one of the great frustrations for me and for others has been sometimes when the language is not precise, and particularly the item in the city recommendations for approval sort of thing is the harmonious with the neighborhood. That is, I mean, that is just such a wide open thing, and we don't agree on it, let alone public agreeing on it. That's just a tough one all the time, I think.
That's your comprehensive plan
Right.
aspect though, which is visionary.
Although I think it's also one of the standards of a conditional use permit.
Oh, it is. Yeah. The conditional use.
So that's, that's one of those tough, rather subjective.
Yep, it is.
It is subjective. But again, you can only rely on what information has been given to you at the public hearing to support the proposition that it is harmonious or not, you know? And so for instance, from a judge's role, if your applicant, so Amy's never going to comment on whether or not it's harmonious because her job is to be neutral. Here are the facts. Here's what the application says. Here is whether or not this application meets our city code. And then that's it. I mean, that's why you never see at the end of her staff report a recommendation for you, because that's not her job. Her job is just to present you with the facts. So it's the applicant's job to come in and say, we meet all of these elements and here's how we're meeting them, and give you the facts to support. There's another slide coming up in relationship to their job to advocate for themselves. That's their job, is to advocate for themselves. So let's say you have a public hearing and the applicant has been silent on whether or not the application is harmonious with the neighborhood, but you have objectioners like crazy saying, I'm next door, this doesn't meet what I have, and blah, blah, blah. Well, there's no weight to give because your presentation on the applicant's side is silent. But that's something to point out in your deliberations, to say it's unfortunate that the applicant was silent on how this project is harmonious with the neighborhood, because we heard loud and clear from the neighbors that it's not. That's a perfect factual application to the elements. And it doesn't require you to make a judgment call. It's because the applicant didn't do their job. And they are coached on this. They are told that it is their job to be the advocate of their project. And that's why we tell you all the time, when you have questions in relationship to the project, unless it's a technical analysis, it's not for Amy, it's not for me, it's not for Sarah. Those questions are for the applicant.
Mr. Chair.
Yes.
Commissioner Camp has a question about deliberations.
I don't think we have to transcribe this record, but I like you practicing.
And just to practice. A few years ago, I felt like we made a breakthrough on deliberations. Used to be fairly silent, and we opened it up. And my question is, during deliberations, should we be requesting permission to speak as we do in the forum like we are? Or can we talk openly amongst ourselves? Because we have a lot of, we'll start before the other one ends, but not in any offensive way. But for the purpose of transcribing.
Correct. So you should first of all go one at a time down the line, or your chairperson will direct, and you should go in order your thoughts. It is a non-judgment zone of this is what I'm thinking right now, and you make it through your thoughts. Then after you all have had an opportunity to express your opinion, then you can start discussing each other's opinion one at a time. For instance, Mr. Chair, I would like to ask Commissioner Boyd a question about her concern with X, and then you can discuss that with her. Or I would like to ask Commissioner McGran why he's concerned about Y, because what you want to do in your deliberations is try to find a way to consensus. You might not get there. That's the other thing, is you don't have to be, consensus doesn't mean you have to be unanimous, right? You're going to have some split votes. I hope we get another commissioner so we don't go 3-3, but you're going to have some split votes. You all have your own mind. You've applied the facts to the standards of approval in your own way. And that's okay. You don't have to have a unanimous vote, but you do want to at least understand each other's opinions and where each other's coming from. If somebody's glaringly outside the bounds, you want to clean up the record by kind of reining them back in a bit. I don't see us needing to rein anybody in this group, but you know, we've had some circumstances where we've been a little off track. But that's what your deliberations are for. And the reason that we're going to talk about a little bit about I may just skip the slides. We'll just talk the violation of open meeting laws. The reason you all can't talk about any of these applications amongst yourselves is because the definition of deliberation isn't restricted to just sitting on the dais in a public meeting. It's any conversation that you have with any other person that helps lead you to an ultimate decision. Sit on that one for a minute. So I haven't had an issue with you guys, or I haven't had an issue here in this city, but I have another governmental entity that I can't get them to understand that when one elected person calls another, that's fine. One, you shouldn't talk about any city business, but you do. And then you take information from that conversation and you call a third person. That's a serial meeting. That's a violation of the open meeting law. You need to conduct all of your business right here on the dais in front of all the world to see, because that's what's required by Title 74, which is transparency in government, transparency in ethical government. So it's really, really important that I mean, if 4 of you are together at a bar, you know, sounds like a bad joke, right? You can be there. Don't even mention that you are planning and zoning commissioners. You can't talk anything about city business at all. You can be there. You cannot talk about city business. And then it goes to, well, the perception is just really bad. So don't do it. But it's the same with emails and text messages and phone records. I mean, none of you want to be in a position where we have an applicant or an affected person that says, I didn't get a fair hearing. And oh, by the way, I'm going to subpoena all your personal phone records. Trust me, that's not a fun place to be. So when I say protecting the process, my desire isn't just to protect the process here. We have to protect the whole process. And I know it's hard because the public doesn't always understand those boundaries. And so you have to have a couple lines in your head ready to say, though I would love to engage in this conversation with you, it's really important that we protect the integrity of the whole process. And I just can't talk to you. I'm really sorry. The end. Most people aren't going to push back on you if you just say, I have an obligation to protect the integrity of the process, and all of what you have to say needs to be heard at a public hearing. And the other thing is, you are appointed to vote. So if you put yourselves in a position where you've had ex parte communication, conflicts of interest, different deal, or you have violated the open meeting law in some way, and you can't vote, well, now you're not doing the job you've been appointed to do. So we don't want you doing things that puts you in a place where you can't vote, because that's what you're here for. Now I just feel like I'm giving a lecture. Wow.
When's the test?
Very informative.
Mr. Chair,
Yes.
may I?
Yes.
So after deliberation, public hearing, we make the vote. So do we still not talk about it amongst ourselves until after the appeal period, or?
So there's a variety of time. Well, there's a variety of timelines on different applications. So if it's a conditional use permit and you're the final decision maker, and then you have to wait the 28 days for 14 days for a motion for a request for reconsideration. No. Yes, I get mixed up. It's final decision maker. So 14 days for a request for reconsideration and then a 28-day appeal period. If you haven't received a request for reconsideration, then likely it's fair game at that point.
Because sometimes people, you know, will in the community will come up to me and ask, oh, you know, just read this, it went to council and was approved. And so I always feel so awkward. Because
your answer is, I am really sorry, but until all the appeal periods have expired, I'm not at liberty to talk about that.
Yeah.
And that again is just protecting the due process rights
right
of the individual property owners or the affected persons. That's another, I'm saying affected persons a lot because there's a misunderstanding that anybody in the city can appeal a decision by you or city council. That's not true. The applicant can appeal and an affected party can appeal. In general terms, affected parties are within 300 feet of the project. So not somebody across town, not somebody down the road. And affected parties, affected persons has a definition in Idaho code, but not every decision, well, not every decision affects every person. So not every person would be entitled to, would have appeal rights. So we have our general complainers where sometimes I just chuckle with myself because I'm like, well, you couldn't appeal this if you wanted to. Well, you could appeal, but we're going to say you're not an affected person and it's going to get dismissed. So the next slide I put up, which kind of dovetails into Commissioner Boyd's question, is just the process for the public hearing. So many of you have been through this already many times. You're going to get an explanation of the hearing procedures by your chairman. So we give him a script and he reads that. Then the staff is going to present. Then your applicant is going to present. And then you're going to have testimony from the public online and in person. Then you have rebuttal by the applicant. The applicant can only rebut facts brought up by the public that were not in the original presentation. And then you close the hearing and you start your deliberations. Once you've made your decision, then Amy's responsibility is to go back and she puts together a written decision for you. And then that gets approved and sent out to the applicant. And it's only upon the approval of that written decision does the clock start ticking. So it's not, and that's another delay. It's not from the night of your decision of the public hearing, even it's after that.
Okay.
So this is where we have talked a little bit already tonight about your public hearing deliberation best practices. So commissioners are called on by the chairperson. I would suggest you kind of get in a habit of calling on each one individually, pick one end and go this way and then pick the other end and go that way. Somebody can choose to pass. They can say, I'm not quite ready yet. Go on to the next person. Give every commissioner an opportunity to speak. And that's, I think, what we got better at. Yeah. So in not having everybody sit silent is really calling people out to express their opinion and making.
And I really like your suggested format of starting at one end or the other with a pass in the middle, so you can collect your thoughts.
Mm-hmm.
I think it just, creates more of a group interaction, which is what we want anyway.
Yeah, absolutely. So during public comment, the members of the public and the applicant, we need to make sure they address the commission. It is never, ever appropriate for the public to address the applicant. Everything is directed at the commission. It's funneling through you. It's your public hearing. It's no different than in a court of law. If you've ever watched court or been in court, the judge doesn't allow these two tables to be talking to each other back and forth and firing off questions, right? They have to go to the witness stand, go through the judge. It's a semblance of that same formality. And then you as a commission in your deliberations, your job is to look at your standards of approval. And Amy is always really good at putting those up on the big screen. And then you start talking about what facts you heard that support the standards of approval or where there's gaps. What's missing, where you didn't hear any evidence. And it's easiest if you systematize that and you go through those points just one at a time. Like, what did we hear in support of this? Or we heard nothing, whatever. That process and that systemization, of course, I'm a systems person, so that will help you not get down rabbit trails that are completely irrelevant. And we've had a few of those. If you see me sitting over here going, you're talking about things that don't matter. It's not part of your standards of approval.
We need that voice to say, Course correction.
So your role during this public hearing process is to really listen to the testimony, take notes, read your staff report, be prepared, ask questions during the presentation. You make second, debate, vote on motions, and then participate in reviewing and approving the written decision. Questions on that? We could probably be a little more robust in our written decisions, but that also is taxing on staff, so. So the applicant's role, we talked about this a little bit already, is to present a summary of their application and then their support for their request. It's to answer questions and then rebut the public, but it's their job to advocate for their project. It's not city staff's job. City staff's not going to do that. It's not their responsibility. It's not your responsibility. It is the applicant's job to advocate for their own project. Any questions on that? It's the citizen's responsibility to come and testify to the positive or negative impacts of the proposal, informing you about the characteristics of the site if it's something different than what you've already seen, suggesting acceptable ones that meet city standards, alternatives or ways to mitigate negative impacts of the proposal. That sort of group of suggestions for comments by citizens is taken directly from case law. So there have been a number of Supreme Court cases that have analyzed public hearings over the years, and that's really what the court has delineated out as where the citizen and the public comments are important. So that's what you should listen for too. Again, I can't tell you how much weight to give that, but that's up to you. This is just further going through things we've already talked about, like where are you getting your information for the decision? You get your staff report ahead of time, review that, be prepared. The application is filled with the facts of the project. So there's a lot of facts in the application itself. You always have that in your full staff. It's attached, right? Or it's in their packet. Mm-hmm. The application is always in your packet. I know based on your comments that some of your tendencies are to read the staff report and only the staff report. Don't do that. Read the application, read the trip generation letter. If there's a traffic impact analysis, I wouldn't suggest reading the entire thing because they're usually about this thick, but go to the last 2 or 3 pages and really read the conclusions and the mitigating impacts and what's required, and understand why they're being asked to pay impact fees, or why there's extraordinary impacts, or why they're not being asked to pay anything extraordinary when you might think, oh my gosh, this is going to kill that intersection. When it comes to traffic also, understand your transportation plan. So, and read it. I would at least skim it with every application that has might have a potential traffic impact, because again, your comprehensive plan, which is your visionary document, which also has your transportation master plan, guides your code. Your code dictates what studies are required for each application. And then you have these applications coming in that you look at it and you go, wow, that's going to really impact intersection X. Well, that's not appropriate for deliberations if that's based on your own subjective opinion. You've identified in your traffic, your I'm losing all my words, your transportation plan, what level of service is acceptable at each of these intersections and at what point it's an extraordinary impact. And then that will have been identified in a traffic impact analysis. All of this data is designed by the rules to fit together so that you don't have to make subjective decision-making. You have data-driven decision-making opportunities, but you have to understand how those pieces all work together. Yes.
Is there ever a point at where it's appropriate on the transportation and grading of our roads where we it's been a thing that's come up. I mean, collectively look at all the projects that are happening as opposed to each one individually. It always has to be each one individually.
Each application gets analyzed on its individual basis, and its trip generation letter is particular to it and the transportation master plan. So trip generation and traffic impact is also using a component of future growth that's already outlined in your master transportation plan. So you've already done that. You've done that vision work to be incorporated into those studies.
So when some threshold is reached that has that negative impact, the consequence of that is going to fall on that current applicant and nothing that came before it.
Sort of and sort of not.
Thank you.
That was a lawyer answer. So two things you never talk about in a public meeting is city liability to your attorney. So, and whether or not this current decision creates liability. So that's like,
yep.
Anyways, the whole goal is for your comprehensive plan, which includes your transportation master plan, to be your visionary document, which is addressing projected growth based on standards you've already approved. So your council has approved, you guys haven't approved. So you basically are being handed the roadmap for whatever data has been used to make the decision that you're going to grow at this percentage over this amount of time, and this is how it's going to impact traffic. That's your transportation master plan. And then you have specific applications that come in that application is analyzed, coupled with the transportation master plan for transportation specifically. If the trip generation is enough that you get a traffic impact analysis, all of that data is going to be in that traffic impact analysis. So when you get to the conclusion of this is what they need to do, all of that has been taken into consideration. Current, future growth, impact. So it is kind of a cumulative look, but it has to be based on data and the data you've chosen to use as a city for your projected growth.
Mr. Chair.
That was a deep dive, probably further than we needed to go.
That was good though.
Yes.
So you're saying to Chairman Hastings' question about the overall traffic impact on approved projects, their accumulation of it, and the effect it'll have on a downstream intersection is visible to the traffic analyst.
Yes.
Okay.
It's a concurrent. So you're getting a report for one development, but they have the data from everything that's going around. So they're assessing that in the bigger picture.
Well, we're just sitting here wondering if they know.
Yes.
Yeah.
That's their job. Oh, but a trip generation isn't going to do that. It's when the project's trips exceed the number that you've already agreed in your city code that if they exceed this number, then they're going to traffic impact analysis. If you get a project large enough that it has a traffic impact analysis, all of that data is in that analysis.
Okay.
And one thing I would add to that discussion is that our transportation plan is multimodal. So it's not just the
Correct.
impact on vehicular traffic.
Correct.
It's also the impact on pedestrian traffic.
Yes. That's a lot.
It does take into account that more trips in automobiles could affect how many trips are available or the capacity of trips in other modes of transportation, like bikes and pedestrians.
The traffic impact analysis will address multi-modes of transportation. Multiple modes of transportation.
This is my skeptical face.
I know.
Just one less thing you have to worry about.
Yeah. Like's been mentioned, we've wondered that openly on a few applications, and I'm still kind of leaning that way, but we're going off information.
But that's a great example. So if there is an expert report, if there is a traffic impact analysis in your packet, and your staff report says there's a traffic impact analysis in your packet, that is the expert information that you have to rely on That is the data from an expert that you have to rely on in making your decision. You don't get to subjectively say, unless you are a traffic expert, which I don't believe any of us are, you don't get to subjectively say, I don't like it. Because I don't like how many minutes I sat at that intersection. You know why? Because that's called arbitrary and capricious decision-making. That's you putting your subjective opinion into what should be a data-driven decision.
Yeah, so when you talk about the last 2 or 3 pages of the evaluation, it should realistically say that it's our recommendation that this has reached its max capacity. And then you can make.
It'll likely say this project or this subdivision is going to have an extraordinary impact because it's going to cause this much deterioration in the level of service. And then there's extraordinary impact fees.
Okay. So then you can decide if you want to approve it or not.
So the other part of that, we might as well just go all in, like head first. Don't forget, your comprehensive plan is your visionary document that you have approved, which you're in the process of doing a new one. That is your accepted, approved projection of growth. That comprehensive plan then drives your capital improvement plan. So your city council approves the capital improvement projects. That's saying these are let's just stick with traffic. These are the streets or intersections that are going to need to be improved based on this projected growth. That capital improvement plan then has dollar figures in it, and that goes into a mathematical calculation to create your impact fees. So your impact fee is saying, we know this subdivision is going to create an impact, and we've already provided for that in our mathematical calculation, starting way back here in our comprehensive planning. And so we city council have already approved those impact fees. You're going to have an impact, and here's how much it's going to cost you to develop here because of that. So when your traffic impact analysis says it's going to go beyond our regular impact that we've accounted for, that's where you get extraordinary impact. So but you can't, and you can only spend impact fees on projects that are on your capital improvement plan. So there's a lot that goes on. There's a lot that's already in place to help you with data-driven decision-making. Approval or not. I mean, I'm not talking about which way you go. I'm just saying there's a lot already in place that's required by code for you to have in place. And if you have questions on those things, when you read your staff report, those are the types of questions you call and ask Amy. So if you get to the end of a traffic impact analysis and you say, why isn't there any data here on the bike lane or pedestrian traffic? Or that's a great question. And we have the opportunity. So if the applicant do their own traffic impact analysis, and then we review. Yeah. So their job is to pay for and provide the traffic impact analysis. And then our professional reviews it and either says, yep, this looks great, it's done well, or no, you missed a piece here, 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 and here. But you're going to get in your packet the result of all of that already. So it's been provided and reviewed.
And in a major project, we would hope that the applicant would be proactive and say, this is the impact it's going to have, and so I'm going to add a right turn lane, or I'm going to do this. I mean,
well, the end of the traffic impact analysis will tell them what they need to do to mitigate, not just impact fees. It'll also address mitigation, other mitigation. So,
and a flip side of that, how it happens sometimes. So if you think back to the Milltown conditional use permit, there were conditions in there that because they hadn't done their traffic analysis yet. And we put conditions in there of the traffic impact analysis has to look at this. Do you need a turn lane in? Do we close the north curb cut? So we'll sometimes do it that way. It's conditioned upon all of that happening.
Gotcha.
And the traffic impact analysis, if they need one, is one of the last things they want to do because it's expensive. I mean, that's not a secret. So if Amy has taken the time to put recommended conditions regarding traffic, pay really close attention to those, or Betsy, or whichever staff. I mean, the report comes from her, so you don't always know which staff person provided that input, but you guys are going to get sleepy on me here in a minute. I'm going to get through this, I promise. Can skip through some of this stuff we've already talked about. This is just kind of a reminder to organize your own information so that you can have productive deliberations. Make sure that I'm a systems person. I said that before. So I will always have a piece of paper with a line down the middle, and on the left side will be the standards of approval. I will have written those out. And then on the right-hand side, as I hear facts that apply, I'll be writing that fact next to each one. So it's just an easy way to keep yourself organized without needing, a bunch of technology. It's a yellow pad and a pen and scribbles. Nobody's going to see it.
May I ask a quick question for you? Just on that last slide. As a matter of practicality, when we have sample motions and when they're.
This is actually telling you to prepare a sample motion, but yeah, we do help with that.
My point is it acceptable to say, I would like to make the motion based upon the legal description as in print and then continue?
Yes.
Rather than read it?
Yes.
Because I think sometimes people, I don't want to make the motion. I don't want to read all that.
The only thing you have to actually reference is the application number. So ours have an application number, and then everything else is in the actual record.
Right.
So
they're already.
Yeah.
So if we want to make a motion, we just reference the application number and make the motion.
Yeah.
For approval or denial.
Yes.
With findings.
With findings.
Findings.
Yes.
And recommendations.
Well, it's a recommended approval or recommend denial with your findings. It's the reason why you're recommending approval or denial.
And adding conditions if necessary.
So what we've kind of let you off the hook on, and Amy goes back and minds the record, is we haven't forced you to articulate on the record in your motion your findings. What we do is we go back, she goes back, and she mines your deliberations, like she mines through all of what you said to each other, and she plucks your findings out of that. That's not the most efficient way to do it.
From all of us?
It'll be from whoever voted yes, which you've had a lot of unanimous decisions. So yeah, she goes back and she plucks them out of there. I don't know how else to say it. Because you have to articulate those in the written decision. It's required by code. So you, for instance, Commissioner Kemp will say, I'm in support of this project because X, Y, Z, and you'll go through a whole list of reasons why you're in support of it. So she, out of the record, then would pull that out. And some of you will say the same thing. So it'll be a collective finding.
And that's why we get emails from Amy at 8 o'clock at night.
Probably, yes. This is where we've just talked about explaining your determination on a quasi-judicial hearing, what the criteria is, what facts you're applying to that criteria, giving your justification in your decision. Oh, you don't want Hayden City Code. I actually removed that one at one point. So we talked about this a little bit. First, discuss. Do not rush to judgment. Do not come with a preconceived idea of how you're going to vote. Make sure every member participates in the deliberations. Identify the applicable standards of approval and relevant facts. So that's where we kind of go back to, and Commissioner Hastings can sort of drive this. He can say, let's look at standard approval number 1. What did we hear tonight in support of, or do we have any information in support of standard approval number 1? And you can talk about that. I think we've kind of gone through that one at great length. I only put this in there because this is the piece I talked about earlier where it says right here, the action. So subsection C says the actions, if any, that the applicant could take to obtain approval. So you are required to articulate the ordinance and standards that are used in evaluating the application, the reasons for the approval or the denial, and the actions, if any, that the applicant could take to obtain approval. So That's in Idaho Code 67-6519 subsection 5. So if you're going to recommend denial or you're going to deny outright, it is your obligation to make suggestions on how they could come back and take another run at it. That is going, I think, in what I'm watching in all governmental entities and sort of land use related conflict, if you will. I think you're going to see a lot more demands for that. We've not enforced that much, but I think you're going to see more demands for that. And what you'll have, it'll be an applicant that comes back and asks for reconsideration or a petition for judicial review on the grounds that you failed to provide them with direction on how they could be successful. And in this culture of conflict right now, that one's really difficult because we have a lot of governing boards who don't want to approve anything. And so, not you guys, but it's just, we're kind of watching this statewide. Yes,
in some ways, isn't recommending approval with conditions kind of doing C?
It is, yes, you are correct. Yep. This would just be an outright denial. If you're going to deny, if they're going to deny or recommend denial.
So how would you go about presenting that? We're
So,
denying this application. And then what?
So that would be a situation where you might table your deliberations so that you can talk to Amy or staff, any staff, between the completion, not completion, but the timeout, during the timeout as to how to do that. So you could come back to the next deliberation prepared with that answer.
And you could do that in the same hearing.
You close the public hearing, you're in deliberations, and you make a motion to table the deliberations pending conversation with staff. Then when we come to the next meeting, we reopen the deliberations. We don't open the public hearing. We just do a continuation of the deliberations, and then you would be prepared.
So there's not a, I'm sorry, Mose.
Oh, I can't wait to do that.
I've seen that. But is there like if you're denying an application?
So you guys are final decision makers on a conditional use permit. So that's always a good example.
As an option of not tabling it and you deny it, can you turn the applicant back to the city?
You are the city. We are the city.
Okay, so they can't go to staff.
It's you're the final decision maker.
Okay.
So you could say, I suggest, we're going, if you want to deny that night and you all have a consensus of that after your deliberations, that's
Sarah.
the direction you're headed. Hi, Sarah.
We haven't been ignoring you, have we? Okay.
Maybe she knows.
I would be hard pressed to, I don't know how to say this. I would want to make sure that what you're going to direct them to do from the dais is appropriate.
Yeah,
that's my concern. Because I don't know that you would know the code well enough to give them appropriate direction. So
I'm guessing it would be better for us to say, well, I guess it's all city staff, but we should say we're going to talk to city staff.
Yes.
As opposed to say we're going to talk to the city attorney.
Absolutely. Yes.
Right.
You would just
even
say,
if you're the one we want the opinion from.
yeah, it's just, we're going to consult.
that.
We need to consult.
Yeah.
I need to consult with city
staff. Yes.
on the best way
Make
to
a motion to
table deliberations for the purpose of having a conversation with city staff.
good.
All right, we're almost done, I promise. So we talked a little bit before about due process and making sure that hearings are fair and impartial, free from conflicts of interest, bias, and ex parte communications. We're going to talk about that real quick. And fair and impartial is really important. Again, I'll land on conditional use permits because that's where you're the final decision makers. Every applicant has a right to a fair and impartial hearing. So for instance, if there is a sexy conditional use permit that's coming forward, that's the talk of the town, we've had it, and I get wind that you guys have been approached too many times, or you've had community members, and this is where they don't understand the boundaries, who have blasted emails to all of you because they want their project approved or they want their project denied or whatever. If you've received too much communication, I can't let you hear that application. So Idaho Code has a provision that allows that applicant then to have an independent hearing examiner. So whether it comes by recommendation of me, because I've received too much information from all of you that you've been bombarded by the public in order to protect the process and the city in the process, I may bring a recommendation that an independent hearing examiner be hired, or the applicant. What we never want to have happen is we come the night of public hearing, whether it's here or council, and the applicant comes in and says, I'd like to make a formal request for a private hearing examiner because I don't believe that this governing body can be impartial and neutral. We never want to have that happen. And then they give us all their evidence on the record of all the ways that people have been on social media. Usually they've been doing blogs, they've email exchanges, text messages, whatever it might be. So the applicant has a right to a fair and impartial hearing. And part of that is making sure that you have not had ex parte communication and that you haven't done research that makes you biased even. So I've explained to council members before that when you are very active on social media and you are expressing a certain philosophy regarding housing, for instance, you've created a public record of your bias. It only takes one applicant coming in and saying, I don't want Commissioner Boyd sitting at this public hearing and making a decision because I do not believe that she can be unbiased. And the reason that I don't believe she can be unbiased is because of this record of her posts or whatever. So be very mindful of putting out in the public what your own personal philosophies are for that reason. Again, you are appointed to vote. Don't put yourself in a position where you can't vote. Conflicts of interest are pretty, run of the mill. You can't make a decision on a matter where it says when the member, you or employee or his employer, business partner, business, blah, blah, blah. When you have any sort of, you're going to gain any sort of financial benefit from or economic interest in any way from the decision that's being made. That's a conflict of interest. And you just can't participate. So if there's a conflict of interest, that's why we ask if there's been any ex parte communication or if we have conflicts of interest. If you think you have a conflict of interest, express it right here in the public, and we will talk about whether or not you can sit. It's better to do it right in the public meeting. And one of the questions I will ask you is, well, are you receiving any economic interest? If the answer is no, then we can go on to, is any family member receiving an economic interest, any business relationship that you have? If it's conflict of interest, if it's ex parte communication, we will express, you will need to articulate publicly the nature of the ex parte communication. And then I will ask you whether or not that will prevent you from being neutral and unbiased.
Would the 300-foot rule from any project be
if you're an affected person?
The same rule of thumb for I should recuse myself from this because I'm within 300 feet of that property?
Should say that I am potentially an affected party because I am within 300 feet of this project and I received notice. And then I will ask you whether or not you can be neutral and unbiased. But you always can make your own personal judgment call to recuse yourself. So if you feel like you have a conflict sufficient that you need to recuse yourself, you can just express it, and then you need to leave the dais and go sit in the back of the room. Okay, conflict, bias, talked about that. So that's bullet point 2, pre-hearing statements by decision maker are fatal to the validity of the zoning determination. So if you do have expressed bias in some way regarding a particular project, this isn't general philosophy, and it's found out later, it'll invalidate the entire decision and we'll start all over. And basically biased decision makers are barred from participating in land use applications to protect the process. That's just the bottom line.
And the case law is from here.
And the case laws from here. Oh, Bonner County has provided quite a bit of case law over the years. Yeah. They're good for business. And ex parte, I think we've talked about that at length. And bullet point number 2, ex parte communications may prevent the continued participation in a hearing, and because it may improperly influence you. Shoo, look, there it is, the end. That's it. That's all I have. So I think you guys were very engaged, and I appreciate that. I hope this was valuable to you. And I think you'll probably, if you're here again next year, you'll see a very similar presentation again. We'll talk about it all again. Grant, if you have any questions, you know where to find us. So
the only thing we haven't said was that harmonious surroundings of the business here.
we might have to have a sidebar on that one.
Could I do have one.
Code updates.
Yeah.
I do have one question.
Oh, yeah.
And that is just kind of the legal relationship between, and I'm thinking more city council, mayor, city administrator. How is that all flowing?
I don't understand the question.
Okay. I mean, it's the mayor is not a voting member, right? Correct.
Tiebreaker.
But he's a tiebreaker only. Gotcha.
Yeah, we so all of the ex parte conflict of interest and bias rules also apply to the mayor so that he can vote if we need a tiebreaker. So he is also to protect himself so that he is available to vote in those public hearings as well.
Gotcha.
Just like
City administrator is the cat herder.
Mm-hmm.
That's her job. She herds all the cats.
The willing cats, right?
Yeah.
When we're discussing comp plan and it becomes a topic of the neighborhood we live in and possible zoning or use, how much emphasis can we put on our opinion of that?
Best interest of the city, irrespective of whether or not you live there.
Well, who would be a better interest than somebody who lives in that neighborhood?
So first of all, comp, your natural tendencies when we work on comp planning is going to be to look at every map and zero in on your own house. So my recommendation is look at somebody else's house. You look at Slate's house, and Slate looks at John's house, and John looks at Ben's house, and Ben looks at Amelia's house, and Amelia looks at Grant's house. So unless you're all in the same neighborhood, you're gonna miss.
Well, I know you and I are.
And Grant.
But you should not make a decision, and you shouldn't even deliberate, although you're not likely going to be making decisions on neighborhoods, just little neighborhoods in general anyways, but you shouldn't, because nothing will taint a record more than it appearing like your decision was based solely on how this affects your house.
Even in the comp plan.
Even in the comp plan.
Just the vision. Like I kind of feel like I said earlier, living in a neighborhood for 20 years, who better to have a vision for that neighborhood?
But we don't comp plan by neighborhood.
Well, yeah. So
I think he's thinking future land use map.
Oh,
yeah.
Well, then that's all just going to come down to. So there are rules of planning, including creating a future land use map that is derivative of your comp plan that none of us are experts in. Probably Amy's the closest. So I wouldn't suggest looking at a proposed future land use map and then changing the color in your neighborhood because you don't like it. Now, we can talk about why it's coming to you in the color that it's in and why maybe it and other neighborhoods might be better suited for a different color. We can do it from that context, but it doesn't, it's not going to make a great public, it's not going to be a great public conversation if in this setting you're focused on your neighborhood. I'll just say that.
Doesn't
So
make good copy.
you look at Amelia's
Mhm.
house.
Okay, so what if it's in an area on the map that you use a lot, you don't live there? Like, let's say it's an industrial area or airport or something like that. You have a strong association with it. Where is my unique value in my life and the things that I do in the city? Where do I have to cut that off when I get here?
You, as long as your unique value and the work you've done in the city and the information you have derived from that is being used to make decisions that are for the best interest of the city and not for you uniquely, you don't have to cut it off.
Sure.
On comp plan.
No.
Now, your neighbor comes in with a subdivision application, that's a different conversation.
Yeah.
Then you have to cut it off.
Okay.
But you get some subjective opinions related to comprehensive planning and future land use map based on your experience.
All right.
I mean, for instance, if because we're relying on a consultant to help us with this, right? They don't know the ins and outs of our city. There are going to be some things we hope that at the staff level, we catch anything that comes in that's not appropriate, but it's going to take all of us to really put critical eyes on this and make sure it's appropriate, but it is also systematic. It is not a, you get an opinion on the future land use map and you get an opinion and you get an opinion and you get an opinion. It is a systematic approach to planning and your vision and your accepted data for growth that drives this. And there are actual principles for planning that apply to this. But there may be some areas that need to be adjusted or tweaked or don't make any sense. That's why it'll take everybody's eyes.
So Fonda, there isn't a problem with us, because I know we had this discussion way back when I first started about, I like to do drive-bys of all the, things that come to us. And I guess I made the mistake that one time of saying, well, I drove by there and it just doesn't seem. So how do we?
Because when you said I drove by there, that was fine. It was when you said it just doesn't seem that you brought in information that wasn't presented anywhere in the public hearing. That was your own subjective information.
Right, because there was the railroad and they wanted to come.
I don't remember what the details.
Yeah, it was the exit or something or other was too close to the railroad, and I think it was a condition that
You could
city didn't
still
want
bring that information in, but it wouldn't be it would have to be in the context of, I drove by there and it appears that number 7, or it appears that this here is not addressing something that I observed.
And that would most appropriately.
Harmonious.
Right, harmonious neighborhood. Most appropriately be asked of Amy ahead of the hearing.
Okay.
Now, the other thing I want to be really clear on, just because I've suggested that you ask questions of staff ahead of time, that doesn't mean you don't ask the question in the public hearing for the public to know you contemplated this. It just means that it gives us an opportunity to have a well-reasoned response for you and not just sitting here going, I had no idea we're going to ask that question and I don't have an answer. So it is not most productive ever for us to not be able to answer your questions. So we want the public to hear what you've grappled with and what your questions are. We just need an opportunity to have an informed, well-reasoned answer for you.
Or maybe you reach out and you say, I have a question about this. This makes no sense. And I'll look at him like, you're right, it doesn't. So then when I come before you and do a presentation, I can say, commissioners should be aware of this, this, and this. Because often if one commissioner's question, more than one commissioner's question, but if nobody says anything,
right,
you don't get the right answer.
But it's also nicer for Amy to be able to front load that. I mean, by now the packet's already published, but at least she can come to the meeting and say, hey, this was brought to my attention. This doesn't make any sense. And she can make an adjustment on the front end rather than we go through the whole presentation. And then one of you says, oh, by the way, what about this? Well, now we're trying to fix it on the fly. And that just doesn't usually work out. But you can do a drive-by. You can comment on what you see at your drive-by. You just can't say, well, I know they did a traffic impact analysis, but I sat at that intersection for 5 minutes, so I think the traffic's too heavy. Oh,
Changing gears.
am I still in the hot seat?
What?
And I'm still in the hot seat?
Yeah. Well, and no, this is just like I said, totally different topic. Generally speaking, the agendas come to us when we want to put something on the agenda. And it came up once when we were talking about ADUs. What is the appropriate procedure for us to try to get a particular item on the agenda?
Or do we?
Or yeah, or that's not our role.
What I advise commissioners is bring it up and the commission discuss whether they want it as a future subject of discussion.
Right.
So it's not just one commissioner saying, I want this on the agenda. It's
Correct.
consensus that, yep, this is something we should look at. That's just it's similar to when people are making motions or there's discussion and one commissioner says, I think we should have a condition of this. Nobody else comments on it. And it starts making a motion like a Christmas tree. So every time someone wants to bring up a condition, it should be the consensus of the commission that needs to be incorporated.
So for instance, that's a great example. Rather than the commissioner who wants to add a condition, making the motion and adding the condition, and then everybody else is like, well, I want to approve the application, but I don't like that condition, it puts you in a bad spot. You make a motion on adding the condition first. So you remember we had that situation not that long ago.
Surprise.
Yeah, so whoever wants to add a condition that's not there says, I want to add this condition, you talk about it, and you say, I make a motion that we add a condition X that either passes or fails, and then you move on to the next motion. Makes a cleaner record. But it's the same with adding things to the agenda. So you bring to the meeting this idea, I would like to talk about X, and then you guys discuss whether or not you want that on a future agenda. And you give, that way you're giving direction to staff as a group, collectively, what we need to be prepared for.
Moving back to the denial, when we deny, it says we have found that it doesn't comply with city code or whatever it says. That's not sufficient, because
Depends on the
other
application.
opposite of that is if you comply with the city code, or then hypothetically it would be passed. And how could we say it will be passed if you do these things?
You can't say it will be passed. You will give them direction for an opportunity for approval. Let's go back to that code section.
Isn't that kind of
It says,
getting into another hearing while you're in a hearing? If you say these things will help you get passed?
it's not getting into another hearing. It's just making suggestions. But that's why I say, don't do that without tabling your deliberations and getting some direction. Okay. So whenever a governing board, I have to move my whole thing here. Hold on. We'll read the whole thing. Whenever a governing board or zoning or planning and zoning commission grants or denies an application, it shall. This is not discretionary. This is a must. It's not a may. It's a shall specify the ordinance and standards used in evaluating the application, the reasons for approval or denial, and the actions, if any, that the applicant could take to obtain approval. So it does give you a little wiggle room with the if any. Every final decision rendered shall provide or be accompanied by notice to the applicant, blah, 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 blah. But
So you're talking, Mo, about conditions that we may bring forward in addition to the conditions we get in our staff report that staff has recommended.
no, he's talking about
denial.
how to tell the applicant from the dais, if you're going to deny it, what they can do to be successful. And that's where I'm saying, don't try to do that. If you're uncomfortable, don't try to do it.
Table the deliberation.
Just table your deliberations.
So next time we are close to denial, we should probably go down that route. That's what I'm hearing.
Unless you have talked to Amy ahead of time or me and have some direction before the meeting starts, but.
Right, again, your decision has to be based on the standards, so you
Right.
would give indication that the application is not meeting standard X, Y.
And here's why it's not.
Okay.
And that statement in and of itself would be enough to give them direction of what they need to do. We don't need to be any more specific with that.
Correct.
They can come up with how they're gonna get around that.
And then they'll likely come back
Right.
through again, revise their application and come back.
Yeah, I'd like to find a way that it could be done in one evening without tabling and coming back in 2 weeks or.
Ask for a recess.
Okay, that's what my next question is.
Yeah.
We can ask for 15 minutes.
Mr. Commissioner, may we please take a 10-minute recess to converse with staff before we complete our deliberations?
So that is an alternative to
Yes.
tabling.
Absolutely.
Great. I like that way better.
And that just takes place from where we are sitting.
So it's kind of like off the record.
Yeah.
Yeah,
that's-
I'd just come up there or Amy would come up there and we'd answer your
Oh, okay.
question. Yeah. We take a recess and you can ask us privately whatever your question is.
And it's not on the record.
No. So it's, we stop everything for 10 minutes. You would say 10 minutes or 5 minutes or whatever amount of time you need.
I like that option.
You would not converse amongst each other.
Hmm.
Because then you're deliberating outside the presence of the public meeting. That's a violation of the open meeting law. It's whichever one of you has a question would ask us.
So so this is tricky then. So Mo has a question he's asking you, you guys answer, then that, spurs questions from us.
You're not going to hear my answer.
Oh, okay, so it's gonna be private.
I mean, we could have 2 or 3 of you, but the
Yeah,
perception of that is not
right.
appropriate.
No, I get it.
So hypothetically, we take a recess, I ask a question on how we deny, how we word, or how I would word a motion to deny with, here's the way recourse that you could possibly be approved if you fix these issues. I word that, we go back into a hearing. I make that motion. Somebody seconds it. We're off.
Roll
and
call
running.
vote.
Okay.
Or we would direct questions if we had questions about whatever it is.
About
that you
what he
secret.
And through that, the rest of the commission could add or.
If you are going to ask for a recess, it's really just going to be because you can't formulate the words in your head exactly.
Yeah.
That would be it.
And then we would still deliberate on the motion after you have
Yeah.
gotten
You
wording that you're
would still
comfortable
discuss
with.
it. Yes.
Yes.
And maybe another recess. Or two.
Maybe, but you,
But then you just table the deliberations.
Yes.
Oh, man. We love being here, but.
It just rolls over to the next meeting.
Yeah, it's not gonna make you.
It doesn't, you
longer.
don't get a special meeting.
Yeah.
We had a special meeting.
Well, they
years
have
ago.
to.
yeah, I remember.
Postpone to a
time.
date
Yeah.
certain, right? So they would say.
I forgot
our next
the case.
regular-
Yeah, they just say our next regular meeting. Exactly.
Now that, we had the executive meeting.
That's because we were in trouble.
Yeah, we were about to be fired.
That was before my time.
And we were.
We can't
we were
talk about
pretty
that.
bad.
That was before our time.
You've not run the foul of being fired yet. Okay, am I off the?
You're off.
Thank you.
Can stop
Thank
sharing
you
a second?
very much.
You're
One more
very
thing I just
welcome.
wanted to, run through, and that is, you get your, we send you the link to the packet, the online packet, and it'll have the agenda report. And I just wanted to kind of make sure that it is clear to everyone when we do that. So you'll have so this is Culver's, this is bringing up the packet for Culver's Crossing, which is fully through its process. So you get a link and it'll say minutes, agenda memo for 7A. And at the very top, it'll give you a link to all the application materials. So it'll take you to that case website. And this is where, I mean, there's a lot of information here, but as Fonda noted, don't just read the staff report, make sure you do read. There'll be the applicant narrative, there'll be the actual application, there'll be the narrative. Under this one, there was the full traffic impact analysis. So there is a lot of information here. And if there's something that you think you would like to have, but is not there, then certainly reach out to us and we'll send it to the whole commission if there's a piece of information. And we'll get it up on the website as well. Although that if we've already posted, is that a problem?
Well, this is already available.
It's true. It's a live link. Yeah.
It's a live.
Yep.
One of the things you should also make sure you look at are the agency comments and responses. Make sure you're reviewing all the public comments that are coming in.
That's all I had.
Do the commissioners have any questions for staff or one another at this time? Oh, yes, Mr. McGrath.
Mr. Chair. So one of the things I'd like to ask for a future near-term agenda item would be a status update on which projects are that we've approved and what their status is. And I think we did this back in August.
Mm-hmm.
And then also what's in the pipeline, because I know there's a tremendous amount of work that the staff does for these reports that come to us and that we read. But what I feel like I get comments from people that I interact with is that they've had stuff in for a long time. And I know there's, again, a tremendous amount of work that goes into it, but it'd be good to have visibility into what that backlog is so that we can have an understanding of what potentially is coming to us here in the near term.
So the problem with that is it's every application and conversation with city by an applicant is confidential until the application is complete and the fees are paid. So we cannot share with you anything previous to that time frame.
That's fine.
Okay. Just so when we talk about pipeline, I just want to be really clear what we can give you and what we can't.
So we can get the status update, but not the pipeline sort of thing.
Well, you can't get the pipeline previous to
Correct.
complete application.
Yep.
I think you'd mentioned in the past that a lot of applications were not complete or they had lots more.
Well, and people who complain about it, I can tell you, I work with a lot of governmental entities. Applications move through the city rather quickly. There is not a lag here. There is not a delay. In the applications where there's been some amount of time from the first pre-app until a complete application and paid fees, it's been because the applicant is absolutely rejecting what city staff is telling them in relationship to what they need to do. It's like, no, here is your checklist. This is what you need to have complete before your application is complete. And they don't want to hear it. They want to come in with their napkin, with their napkin, and they want Amy to tell them, yeah, we'll get that in, 6 weeks from now. No. So the other part of that, I appreciate you bringing that up, Ben, because the other part might be going through with them. What has to happen from pre-app, from the very first pre-app through a complete application, so that these guys even understand all the work that the applicant has to do to get to a complete.
Yeah, like how far down the checklist they are.
Right.
What
So
is the
it's
timeframe?
just more information for you when they start complaining to say, okay, well, I know these things all have to be done. Have you done this, and this?
So, Mr. Chairman, Mass.
Yes.
So Amy, I'm wondering, and not to disclose anything personal about, anything
Pre-app.
filing, yeah.
Complete app.
But it feels like you might be able to get an aggregation just in terms of how many like partials and you know what I mean?
Yeah.
Get a
We can
sense.
do some numbers.
Because there's probably quite a swelling from time to time and it'd be good to get.
Yeah, we did our year-end numbers, both of building permits and planning and zoning actions last year. So, last year's planning and zoning actions become building permits this year.
Gotcha.
And then some just take longer, like Milltown was approved here, boy, it seems like so long ago now. And that's what's been holding it up this whole time has been their traffic analysis. It's just, you know, they have to reach out to consultants, find consultants that have the time to do it. So, but they definitely are going to get going this spring.
So on average, what is it from walking through the door with first time?
Yeah, it just depends. Is it a subdivision? Is it a rezoning in a subdivision? Is it a PUD? Is it a CUP? Just it very much depends on the project.
What it is.
So that I think, so let's just use the request as a practice. So you're requesting sort of an update on the pipeline and generically projects coming forward, yes, and then some overview of what's required from pre-app to complete application. Do we have the rest of the commission or someone else on the commission who also is wishing to have that information?
Yeah, yes. I'd love to see the whole process. Well, for each one, CUP.
Each different application.
Yeah,
okay.
I mean, that would definitely be good to know because, you know, I definitely don't know the whole process.
So I think based on this information, this conversation, that's an appropriate agenda item in the future. How quickly, I don't know how soon we can get that, but.
So where do we, in the meeting, if it's not on the agenda to discuss future agenda items, where would that be appropriate before we adjourn, or?
So after new business, it says, do the commissioners have any questions for staff at this time? At the end, and Chairman Hastings always asks that question. Commissioners have any other questions? It's sort of like your commissioner roundtable.
Well, that generally is after each action item.
Yeah,
that's
so
true.
Maybe we can add something.
Well, we can add a roundtable discussion for the commissioners at the end. It can't be discussion because you can't talk about anything substantively that's not posted as an action item. So you can't surprise us with a substantive discussion. But we could put a roundtable on there for agenda item suggestions or additional questions.
Could it be, is there anything else for staff?
Yeah, absolutely. Yeah.
Or it could also be, do commissioners have items they'd like to discuss at the next meeting?
Don't say next meeting because oftentimes our agendas are already set.
At a future meeting.
Meeting. Like we have a public hearing schedule that's already coming down the pipe. And we have to schedule those by figuring out. So if they're going to council, we have to go to the council date and when is that available and work back. You guys are more flexible, but those council agendas are really tight and pretty much scheduled for a while. So we have to squeeze them in.
Mr. Chairman.
Yes, Mr. Jones.
Did we need to approve minutes from last meeting?
I didn't put them on this agenda. They'll be at your next.
All right.
That'll be next time. Commissioners, any other questions?
Sir.
Well, with no further business before the commission, this meeting is now adjourned at 7:27 p.m.
Thank you.
Thank you.